convict on the lesser? Where's the absence of evidence of utter disregard for human life?
Judge, there was a line of questioning on the cross-examination of the defendant in which Attorney Binger asked, I believe in regards to each person shot or shot at, except for that of Mr. McGinnis, I suppose, if the defendant, I can't remember the exact wording, but if he even cared if he killed the person alluded to. So I believe that the defendant denied that he said he had to shoot him. He denied that he did not care about their life. So I believe the jury could find, based on that line of questioning, as well as just the evidence in general, that the defendant did not have an utter disregard for human life, as he testified. He testified that he essentially had regard for human life because he felt he had to do it, and he didn't really want to kill anyone.
Well, let's hear from the defense.
Judge, element 3 is the circumstances of the conduct showed the utter disregard for human life. And in terms of the evidence in the case, I think the testimony was he didn't want to have to do it, but he did it to defend himself. So, as I said in our instructions, I don't think that there has been any evidence offered which would support the lesser included on count 1. So I would ask the court give 1020, which is the first-degree reckless homicide charge, along with the self-defense instruction, and that'd be that, because I think that's what the evidence shows.
I'm going to do a colloquy with your client when we get done with all this. And, don't let me forget, please.
I've discussed it with him.
Yeah, but I got to talk to him personally. The instructions says, in determining whether the circumstances of the conduct, and that's a correct point, the conduct showed utter disregard for human life, consider these factors: what the defendant was doing. He was firing a gun into, let's see, this is count 1, so we're talking about Mr. Rosenbaum. He's firing a firearm 4 times into a human being with fatal consequences. Why he was engaged in that conduct, how dangerous the conduct was, well, that's self-evident. How obvious was the danger, that's self-evident. Whether the conduct showed any regard for life, and all facts and circumstances. I don't see it, and I don't see it. Help me out where I'm going wrong.
Well, Judge, he was asked if he, not only did he, how he felt about killing them, but if he knew that his conduct would have killed him, and that firing that gun would have killed someone.
This element is on first degree, which is what we're not talking about, is whether he knew or was practically certain. And we're talking about reckless endanger or reckless homicide. So, I mean, to fire a gun 4 times into somebody, you don't think you'd know or have or be practically certain that that could have fatal consequences?
I would, but the defendant denied that it would.
He didn't. I didn't hear him deny it. He said he was protecting his own life. I thought he was, when he was being asked repeatedly, and correct me if I'm wrong, he was asked repeatedly questions along the line that you indicate, and he responded, I was trying to defend my life.
He was also asked the line of questioning, you knew if you shot 4 shots that you would kill him, and he denied that he would have that knowledge. So I mean, I agree that, I mean, I obviously think that it's utter disregard because that's what we've charged it as, and that's what we have presented to the jury, but I believe a reasonable jury and a reasonable juror could, based on the defendant's own testimony, not find utter disregard for human life. And that's the standard, not what we think, but what a juror could do.
I wish I knew the exact answers that were given. I'm not sure, and I when I say that, it doesn't mean I'm embracing your interpretation of what that would mean, but I would want to be sure exactly what was said anyway. So, are you able to identify when in the examination? Because you had a very lengthy examination.
Check my notes.
And, unless it's crystal clear, my suspicion would be if it turned out that the defendant would be acquitted, well, not acquitted, but if the jury returned a verdict on second-degree reckless endangerment with this description of what constitutes the crime, if they returned a guilty verdict over the defendant's objection, I would expect to be reversed.
On second-degree reckless endangerment?
Yes, or homicide, I'm sorry.
So, you're saying if the jury finds the lesser
On this charge,
and the defendant objected,
over the defendant's objection,
and you accepted it,
right?
you felt it would be reversed?
Yes. Unless you can come up with this crystal clear language that the defendant, and again, we're back to the circumstances of the defendant's conduct showed utter disregard for human life. So I think his thoughts on the subject would be relevant, would be a legitimate factor, but when I consider the others, what he was doing, firing into somebody 4 times, why he was engaged in it, there's dispute about that, but either it was it would certainly be reckless under any circumstances, and except under privileged circumstances. How dangerous it was, how obvious was the danger, and whether the conduct showed any regard for human life. And if anything, it seems to me he would have indicated, if you interpreted his answer, it would be an indifference. Although he did say at one point that he didn't want to kill anybody, but it would be an indifference, because when he's asked about his intent, what was the question you're saying again?
There was a line of questioning on if he cared about killing someone or cared in that regard. And there was a line of questioning is you knew that firing the gun could cause death, and I believe he denied or indicated he didn't know.
I don't remember that. Did
everything that he said, I mean, the reality is everything was an intentional act. Now, they haven't charged it that way, and I appreciate that. But looking at the definition of utter disregard under the statute, I'm not going to repeat. I'm going to hold the same ground that you've already done. Firing 4 shots, we have evidence that the man grabbed the barrel of the gun. So we're talking about a distance of inches, not always feet, but in some situations, inches. It is the only logical conclusion would be that a person would believe that conduct, if they were convicted, would show an utter disregard for human life. If self-defense isn't accepted, there's no other reasonable conclusion that can be drawn from firing a gun somewhere between 1 and 4 feet, all the way down to inches, by the soot on his hand. So I think that's what the evidence showed, and I think that's really the only evidence regarding the utter disregard portion of the statute. So
if the defense is willing to stipulate to the third element, then that's fine. We can go with that way. But it seems they're not arguing it. And if we want to go that way, then we can.
Conversations with lawyers are always interesting.
And if they're not willing to stipulate it, then obviously there must be some disagreement, or they must be trying to argue it. So I believe that there is a basis. I cannot recall at this moment precisely where in the cross-examination it
No.
occurred. Obviously,
you
it was
should.
lengthy, and I wasn't the one conducting it.
The examination, as I recollected, was that the defendant was repeatedly asked about the question about his thoughts on the subject of the death or survival of the target, and invariably responded that he was trying to defend himself and that he'd be killed if he didn't. And if anything, I would interpret it as an indifference towards the outcome with respect to the target, which is not identical to utter disregard.
Right, right. So if he's indicating he has an indifference, that would be second-degree reckless homicide.
Now, it would be one factor, and I don't, even if I granted what, I just don't think it's appropriate. And as I'll repeat my statement, if I were to give this instruction over the objection of the defense and the jury found a verdict on it, I would expect to be reversed.
Well, are we in agreement that element 3 is present?
Well, don't ask me. I'm not in a position to agree to anything. I'm not going to give that instruction. Or submit that verdict. 1345 and 1347. Second-degree reckless endangerment.
So it's essentially the same issue.
Yeah, it is. So, any additional argument on that?
It would be the same for count 3 as well. Well, counsel raised a good point to me that he claims he didn't even know Mr. McGinnis was there. So he's firing a weapon whose he admits does not know the capabilities of. He admits he doesn't know how the bullets can react, that he did not know a thermal metal jacket could pass through his target, and he's really showing utter disregard for anyone in the line of fire as he fires 4 shots, including Mr. McGinnis. There's also bystanders. There's a house directly behind Mr. McGinnis. So I believe in firing 4 shots in a somewhat, I would say, wild manner. He is showing that there could be an argument that he says he didn't. I believe, again, that it's utter disregard, but a jury could find, because he did not know Mr. McGinnis was there, that he was not showing utter disregard for Mr. McGinnis's life, and that the second-degree endangerment would be more appropriate.
Defense?
Just give me 1 second here, Judge. Because it stems from, and tell me if I'm wrong on this, because it stems from the actions involving Mr. Rosenbaum, which this court believes the proper instruction deals with the utter disregard for human life of Mr. Rosenbaum. Those actions, to me, are intertwined with the charge involving Mr. McGinnis.
No, I don't think so, because I think the instruction anticipates that he could have utter disregard for the life of Mr. Rosenbaum, but still be sufficiently aware to realize the risk to Mr. McGinnis, and then he, under the law, as I read it, he would have the obligation to exercise his conduct is in such a way as to minimize the risk to Mr. McGinnis, whether privileged or not. He would, even let's talk about his conduct being purposeful, even though it's not charged. If he intended to kill Mr. Rosenbaum, and whether he was justified in that or not, he's still required to execute his intentions in a way with the minimal, or to minimize the risk to Mr. McGinnis. So and that's a jury determination, I'm not suggesting I would want to be in that position, who would, but he would have to decide, well, I've got to kill this guy, but I've got to do it in such a way that I don't hit anybody else. That's really what the jury's being asked to determine. And there are instances that you could imagine where the person actually would have freedom of choice and a conviction could be appropriate. One might not expect that to happen under most self-defense circumstances, but although for an intentional, then he'd be guilty because he intended to kill someone else.
And here's my only argument is, I think the testimony was the bullet that has endangered McGinnis passed through Rosenbaum, right? That Rosenbaum was shot, there's 5 wounds with 4 shots, so he didn't miss. So the reason that I'm kind of hung up on the utter disregard for Rosenbaum is if he would have missed, I suppose, and you could say that shot was a wild shot.
But he was using steel-jacketed ammunition.
Bullets are bullets, Judge.
No. I'm picking at hairs because that's what we lawyers get paid to do. But and of course, if we were in the jury room, and we'd laugh at each other for the things that are being said. But in the eyes of the jury, they could theoretically, like how many angels fit on the head of a pin, they could theoretically think, well, it does make a difference because he wasn't using expanding ammunition. He was using a full metal jacket, and he should have foreseen that it might have gone through and that it would endanger someone else.
The defendant also denied knowing he was there, so the jury could very easily...
He did indeed. That was my next point.
My only argument, Judge, was that if he's using utter disregard, or the jury believes there's utter disregard as it relates to Mr. Rosenbaum, the charge as it relates to Mr. McGinnis directly relates to the bullet that went through Mr. Rosenbaum's hand or head or whatever it is, right? So that's why I'm saying if it's that for Rosenbaum, it has to be the same for McGinnis, only because there's not a wild shot. He didn't miss. He wasn't spraying. Nobody's alleged anything like that.
You could say that in your argument, couldn't you?
We
if
could.
they left this on their verdict and you had to argue it, you could say.
I certainly could.
Pardon me?
I said I could.
The evidence does show that he essentially missed the 3rd or 4th shot. There's a graze wound that then traveled who knows where, possibly towards Mr. McGinnis. So this is not as though all 4 bullets entered Mr. Rosenbaum. One skipped right by him and basically had a contact wound. And the defendant says he didn't think he was there. So a reasonable jury could find that how do you show utter disregard for Mr. McGinnis when the defendant claims he didn't even know he was there?
I'm going to think about this one. My inclination at this moment, to repeat my former statements that have caused some consternation, my bias would be in favor of submitting that verdict and giving this instruction. But if it shows up on your doorstep, your email doorstep tomorrow at some point, and it isn't in there, don't be terribly surprised. All right.